This is John Siegel from Scheer Law Group. I'm here today to talk about what happens when a tenant moves out but leaves his personal property behind. I get calls on this issue all the time. First thing that has to happen is the tenant has to be given notice that he has an opportunity to come back and get his personal property. Now, if the tenant moved out pursuant to a sheriff's lockout, then the sheriff will post that notice himself. You don't have to do it. Under those circumstances, the tenant will have 15 days to come back and get his personal property. Other than a sheriff's lockout, the landlord has to serve notice on the tenant. And that notice is going to be 15 days if you can personally serve the notice on the tenant. In other words, you know where the tenant moved to, or you know his work address, and you can find him and personally serve him. Otherwise, you have to mail it to the tenant. If you mail it to the tenant, then he gets 18 days notice. And next is what happens if the tenant doesn't reclaim his property by the time the 15 or 18 day notice expires. And how the landlord should treat this depends on the value of the property in its current condition. If the property is reasonably valued at less than $700, then the landlord can do what he wants with it. He can keep it, he can throw it out, or he can give it away. If the property is worth $700 or more, then the property has to be auctioned, and there are statutory requirements for how to conduct the auction. But it does have to be auctioned. If there are proceeds that are received from the auction, the landlord can keep as much as it cost him to market and conduct the auction. Any excess beyond that has to be given to the state. Another question my clients ask me about is storage. Often landlords would like to get the personal property out of the premises immediately so they can start preparing the premises for the next tenant. And you can do that. You can move the property into safe storage right away. And in fact, if later the tenant claims his property, you can, as a condition for him getting the property back, you can require that he pays reasonable storage fees. There's one exception to that though, and that is if the tenant claims the property within 2 days of service of the 15 or 18 day notice, then you can't charge him reasonable storage fees. So quick summary, a 15 or 18 day notice needs to be served. If the tenant doesn't request return of the property within that period, then if the property is worth less than $700, the landlord can dispose of it as he wants. If the property is worth more than $700 or more, then it will have to be auctioned. If you have any question about this, any landlord-tenant issue, or any real estate issue, please call me at 415-491-8900. Thank you.